those costs can take a variety of forms, some of which are attorney's fees, some are just other sort of ancillary expenses that might come up. But they're expensive, and it's that entire process can be very costly to an estate. So today we're going to be talking about ways that you can minimize some of those expenses. As always, if you have questions as I'm going through this, you can submit them to the Q&A function, and I will see them come in, and I can answer them. Also, keep an eye out for an email from us after this webinar. The one you used to sign up for today is the one you'll receive the email, or that will receive this email. But we always send out a feedback form, and that feedback form gives you a couple of things that you can fill out. One is, of course, just feedback, but you can also fill out whether or not you'd like us to reach out to you to set aside time for a initial consultation. With our office, initial consultations are complimentary. We don't charge clients anything to come in and talk to us. If by the end of that meeting we have a recommendation for you, we can generally give a good estimate of cost for you. But we do schedule those meetings for about 2 hours, and that gives us time to run through everything and make sure that we have a good recommendation for you by the end and have had a chance to talk through all the possible concerns. But all right, so going into just our topic today on estate taxes and administrative fees and just other taxes that might come up for people. Just sort of addressing the elephant in the room when it comes to the topic is, we're talking about estate taxes as one of the key taxes that people might need to be aware of. But in reality, estate taxes are not a major concern for most clients. Now, it certainly can be for some people. And if you have those concerns, there's a lot of things you can do to minimize those estate taxes or eliminate them entirely, depending on the value of your estate. But when we're talking about whether or not you have a taxable estate, I mean, it used to be in the past, it was much, much lower. So the reason this is than it is today. And the reason this is a very common concern for people is a lot of the advice that's out there, a lot of the articles that are out there, or just sort of the conventional wisdom that's been passed down is related to what those exemption amounts used to be back in the early 2000s or the 90s. And the exemption back then was very low. It was anywhere between about 600,000 to $1 million. So if you had an estate value that size, you had a taxable estate, or a estate size that was higher than that, you had a taxable estate. And it's not an insignificant tax that was owed. The exemption in today's world, though, we have currently on a federal level, per person, each person has to have more than $13.61 million to have a taxable estate. So if you're married, that means you have to have more than $27 million together to have a taxable estate. So when we're talking about estate taxes, we're not generally worried as much today for the vast majority of people like we used to be. Now, some states have varying state level estate taxes. Wisconsin is not one of them. We don't have a state level estate tax. Another common misconception when we're talking about estate taxes or what taxes will be owed on somebody's estate has to do with this idea of an inheritance tax. And that's where people think, well, what taxes are my kids going to have to pay on the amount they receive? So an estate tax, the difference there is you're paying taxes on, or your estate rather is paying taxes on the amount within the estate, the total amount it had. That's what's paying the tax, not the kids themselves. Now, it would certainly lessen the amount that the kids ultimately get, but that is the estate tax side of things. An inheritance tax is when the people who are receiving the funds have to pay a certain amount of tax on the value of what they've received because they received above a certain value themselves. Federally, there is no inheritance tax, and at the state level here in Wisconsin, there is also no inheritance tax. So it's not something that most people really need to worry about on the inheritance tax side of things. And on the estate tax side of things, it can certainly be a concern for people, but it's such a high exemption right now that we don't run into it a whole lot. But when we are talking about, well, how can we possibly minimize that estate tax issue for people who do have close to that level or may have above and beyond that level when they pass away, there are some key strategies that can be used. Before I go into those strategies, one thing to keep in mind here is that that 13.6 million, one, it gets adjusted for inflation every year, so that'll go up next year again. But when that exemption was put into effect back in 2017, at that point it was $11 million. They only had enough congressional support to make it permanent, or not permanent, make it last for about 8 years. So at the end of 2025, so at the end of next year, starting in 2026, that exemption amount will sunset, go back down to what it was indexed for inflation. Projected, it's supposed to be about 6 to 7 million with inflation. It was a 5 million exemption that was indexed up for inflation at the time. So it is possible at that point that a lot more clients, a lot more of the population just of the country will have a taxable estate. So even if right now you're not near that 27 million, if Congress doesn't agree to keep that exemption going, they're going to cut it essentially in half starting in 2026. And that means that even if you aren't at that exemption amount now, you might be close to that when it goes back down. So keep your eye on this, keep these strategies in mind, because it could ultimately impact you. So when we're talking about strategies around estate tax planning, one of the most common tools that people might use to get things outside of their taxable estate without incurring an estate tax liability themselves is using what many people are familiar with, the annual gifting exemption, the annual exclusion that you have for gifts. Now, one thing to keep in mind here is these annual exclusions do not apply for things like Medicaid availability, Medicaid divestment. So if you're concerned about nursing home expenses, this is not a strategy you want to use because it can be a problem if you would need Medicaid assistance at some point in a nursing home. But if we're talking about somebody with taxable estates, we're generally not worried about somebody who has Medicaid concerns or about them having Medicaid concerns because they should generally have enough to self-fund their care. So this gifting amount, many people still think it's a much lower amount than it is today, mostly familiar with what it used to be. Sometimes you'll hear people say it's $10,000 a year. Sometimes you'll hear $15,000 a year. Well, right now, this year, it actually went up to $18,000 per person per year. So what this means is I could gift to every single person I wanted to up to $18,000 each, and I would not have to file a gift tax return. What that essentially means is that if I don't have to file a gift tax return, I'm not going to have my end of life exemption amount, my 13.61 million. That's not going to be decreased by any amount because I didn't gift over that annual exclusion. Now, if I gave one person $50,000 in a given year, I would have to file a gift tax return. And what that ultimately does is that first 18,000 of it doesn't lower my end of life exemption, but the amount over that up to that $50,000 would decrease my end of life exemption. So when we're talking about doing this gifting strategy, a lot of times it's transitioning up to that amount to a few different people. A lot of times it's the kids or grandkids. I mean, there can be a lot of strategies with this where you're not going over that amount, but if you are married, for example, not only can you give that $18,000 to each of those people, your spouse can as well. And so you have a way to move quite a bit of money over the years and avoid paying estate tax on that. Now, that's a very simplified view of it, and there's oftentimes certain types of trusts that people would use to do that as well, especially when there's younger kids involved or minors involved in general. You'd want to be careful about just giving them a bunch of money, but that's essentially how that strategy works, is you're not incurring an estate tax liability because you're gifting within the annual amount that you can gift. Now, that may not be aggressive enough for some people with incredibly large estates, and there's more complex planning that can be done using certain types of business entities to lower the value of the estate, getting discounts on like business assets. But just from a standard kind of point of view, for most people, that strategy can actually be very effective. Um, so planning using trusts is a huge tool that can be used to help eliminate or at least lessen the impact of estate taxes. One of the most common strategies that people might use to effectively eliminate their estate tax liability is if they, for example, have a revocable trust and they're married. There's a lot of planning that can be done on the death of the first spouse that can move some of the funds outside of the taxable estate so that when the second spouse dies, they don't pay estate taxes on that amount. It's not part of their taxable estate anymore. So this is often where on the first death, some amount will stay with the surviving spouse, and some amount will go into something called a family trust or a Q-tip trust. I mean, there's a lot of different ways that this could be established. Sometimes you'll hear it referred to as like A-B trust planning, but it's all the same thing. Essentially, some amount stays with the spouse, some amount goes out to a separate irrevocable trust at that point from the surviving spouse's assets. It can be used for the surviving spouse's benefit. They can receive funds from it, but there's certain restrictions on it that make it not part of their taxable estate. This is not going to be the best fit for everybody, of course, and it's especially not a good fit for people who are nowhere near having a taxable estate, right? There might not be reasons from an estate tax standpoint for doing this. Now, some people will use it even if they don't have taxable estates to protect against remarriage of a surviving spouse impacting where their funds ultimately go. That can be a great use as well, but for the estate tax component of it, it's not likely something you'd be looking ahead at doing unless you're maybe close to that estate tax amount or could be with that sunset at the end of 2025. Another really common strategy is, and a very effective and somewhat easy one to do, is if you're very charitably inclined, maybe you're not somebody who has kids, you're leaving the bulk of your estate to charity. Well, any charitable donations during lifetime they can help lessen that estate tax, and those are not subject to that annual gift tax amount. You can also give a lot away at your death, and that is a deduction so that you don't have to include that in your taxable estate. It lowers your liability there. So if you're very charitably inclined, that can be a very effective strategy to eliminate estate taxes, or at least lessen them, depending on the amount you're leaving to charities versus individuals. But that ultimately is more a case-by-case situation, and that's not going to apply to everybody. If you're not charitably inclined necessarily, that's not always the best strategy because you want money to go where you want it to ultimately go. You want it to be tax efficient, of course, too, but don't leave money somewhere that you have no interest in leaving money to simply to accomplish a tax result. That's not always the best idea. So charitable giving is a great tool, but again, very kind of case by case specific. So kind of moving on from estate taxes, because like I said, this is not a huge concern for most of the population at this point. Regardless of the size of your estate, there's always certain taxes that you should be aware of because some of these taxes you can effectively plan around to minimize the impact. Some you can avoid entirely if you do proper planning. One of the most common tax issues that's created after someone passes away is actually capital gains tax. So that's generally tied to any gain associated with things like real estate or stocks that somebody owns. Now, if you hold those assets in your taxable estate when you pass away, you get a step up in cost basis. So what that means is when determining whether you have gain on a property like your home, the IRS looks at what did you pay for it versus what was the sale price. Now, when we sell our primary residence and currently under federal law, we don't pay capital gains unless we have a gain of more than $250,000 per person of the residents of the home who own it. So if you're married, that's $500,000 in gain, right? It's not very common that gain is that large. Now, it can happen. But if it's not your primary residence, if it's like a secondary home, a vacation home, a investment property that you're using to rent out to people, right? You don't get that same exclusion from capital gains. So essentially what that means is if you were to sell your second home, you may pay capital gains on it if it's gained value since you originally bought it. I mean, likely you would. The problem that people often create for themselves is rather than waiting for their children to inherit these properties, they put it in their name. They deed it over to them and just gift it to them. The problem with doing it this way is that what that means for tax purposes is the IRS will say, well, we're going to say that the kids bought it for whatever you paid for it because they didn't actually pay anything for it. You just gifted it to them. So it's a transferred cost basis, is what that's called. The problem with that is that they then, if it's not their primary residence, don't get that exclusion. They will have to pay capital gains on the difference. And that's a 15 to 20% tax on the gain, depending on where their income level falls. But had they inherited that property after, like through your estate, so not received it before your death, that cost basis actually gets adjusted up to fair market value at the date of death. So what that essentially means is that if you inherit real estate through somebody's estate and then you turn around and sell it, it doesn't matter what mom and dad paid for it originally. It matters what the value was at the date of death. And if there's no gain from that date or very little, you may not have to pay any capital gains tax on it at all. So you would much rather inherit things like this than be gifted this type of asset. This is the most common problem we see people create for themselves because they're trying to do things like protect the home from nursing home expenses. So they gift the home to the kids to get it out of their name. And then maybe they never actually needed nursing home expenses or nursing home care, excuse me. And so the expenses of that care were not an issue. But now they've had this built-in tax liability that could have been avoided and they could have still accomplished their goal to protect the value of the home from nursing home care in a much more effective way. And usually that's using some kind of irrevocable trust to do it. But this kind of issue comes up a lot, especially with like farm families where they've maybe gifted land over and there's very low cost basis in it because it's been depreciated down substantially over the years. It comes up a lot with primary residences too, of course, but it's a very common issue and a very easily avoided one where you don't have to worry about paying those capital gains tax, at least to that amount. The other tax that we're often concerned about these days actually comes in the form of just ordinary income tax too. This is not necessarily saying that what your kids receive, they just have to pay income tax on. That's not how this works. But when it's an asset such as a pre-tax retirement account, something like an IRA, a 401k, 403b, any of those types of assets, those taxes don't just go away because you contributed to them without paying the tax, assuming it's not a Roth again. That's a different situation entirely. But you don't pay tax when you contribute to a traditional IRA or 401k. You just put assets into it from your paycheck, don't pay tax on it. So that tax is not just going to go away. Either you pay the tax on it when that money comes out, or once it's inherited by the kids, as they take money from it, they have to pay the tax on it. This has always been a concern, of course, even going back to the start of these accounts. But prior to 2020, you could actually, as the beneficiary of these types of accounts, you'd have to start taking distributions right away from it, but you could stretch it out over your life expectancy. So somebody in their 30s, 40s could stretch it out decades before it would have to be fully liquidated. And that would stretch out the tax that long too. So it wasn't, even though there was some tax owed on it, a lot of times it wasn't like a major concern for some of these accounts. But after 2020, there was a law that passed in Congress that's called the Secure Act. It minimized the amount of time that these beneficiaries had to take out these accounts and pay the tax. So now the maximum time for most people to liquidate these accounts is about 10 years. There are some exceptions to that 10-year rule, like somebody who is a minor child of the original account owner can take a stretch until they're 18 and then they have 10 years. excuse me, 21 and then 10 years actually. A Somebody who has a disability, chronically ill individual can take a life expectancy stretch. A spouse can still do a rollover. I mean, there are some exceptions here, but the vast majority of people's children who are inheriting these accounts are not going to stretch it farther than 10 years. So that is a huge increase in that potential tax liability because obviously, if you take out taxable income faster and in larger amounts, you're going to have a higher tax rate on it. Most likely, it's more likely to put you into a higher tax bracket than stretching it out further. So there are things you can do during your lifetime to potentially minimize that tax for the kids. First and foremost, if you've ever talked to your financial planners or your CPAs that you work with about this, there's something called a Roth conversion that you can do where you decide how much you want to do with this per year. You don't do it all at once, that wouldn't make sense. But you pay the tax on a certain amount of your IRA and you put it into a post-tax Roth version of that account. And that grows tax-free. You don't pay tax on it. The kids don't have to pay tax on it. So if you're planning far enough in advance, you can potentially eliminate that tax entirely. Now, you're going to pay the tax on it, but it's all about strategizing with your CPA and your advisors to minimize the tax between you and your kids. It's very likely that your kids are going to be in a higher tax rate than you are when you're in retirement, when they're inheriting, that is. They have to take it out more quickly. Tax rates at some point in the future are almost certainly going to be higher than they are today. So there's a combination of factors that makes this very appealing to at least consider. It doesn't make sense for everybody. Another strategy, again, is with charitable giving with these IRAs. You can, instead of taking your required minimum distribution, you can do what's called a qualified charitable distribution, which is it goes directly from your retirement account to the charity or charities of your choosing. And so then you don't pay the tax on it, and the charities don't pay income tax. So it's a very effective strategy. You can also, if you have charitable intent that you're trying to leave behind after you're gone, after you've passed away, you can just leave the pre-tax accounts directly to those charities. Now, I'm not saying you have to leave the entire thing there. It could be a combination of, percentages and all of that, but it's much more tax efficient for them to get the pre-tax money directly than it is to have the CPA do a deduction from what income might have been owed otherwise later on. So just if you're charitably inclined, consider using those pre-tax funds specifically for those charitable wishes. So those capital gains taxes and ordinary income taxes, those are by far and away the more likely concern that you will have. They're a concern that everybody will have, regardless of whether they have a taxable estate. Everybody's going to have to deal with it or plan around those expenses. But the estate tax side of it, it's a very important thing to be aware of. It can be an issue for certain people, but don't think that it's an issue for you just because you hear about it. It's not always an issue. It depends on the value of your estate. You can do very well in life and still not have a taxable estate these days. Obviously, if you have a taxable estate, in some ways, you might consider that a good problem to have because that means you have that much money that you've accumulated. Now, one thing I didn't mention on estate taxes that can be a good strategy, even if you don't have a taxable estate, though, is how you would set up your like kids' inheritance, for example. So when you're setting up your children's inheritance, what you would essentially be doing is looking at, do we just give the money to them directly, or do we set up an inherited trust fund for them? A lot of people think that you only do that for minor kids or people who aren't responsible, and that they can be used for that purpose, but there can also be things that you might be trying to plan ahead for future generations. So we don't know what the estate tax is going to be at any given year in the future. They could, by law, change it to a much lower amount. They could increase it substantially. We just don't know. It's all up to Congress what they decide to do with that. So what that means is that what is not a taxable amount today could be at some point in the future, especially if it's invested and it grows and accumulates after generations. So when you have an inherited trust fund, you can put language in that for that beneficiary that gives them the option to choose between, do I lessen or eliminate my estate tax liability from this money that's within this trust? Or am I more focused on avoiding capital gains taxes? And there's very good language that you can put in there that has been tested and effective with the IRS. So you may not be looking at your own estate tax liability. You might be looking ahead to the kids or the grandkids. I mean, this is really good planning that you can do. Now, again, if you have a relatively modest estate, if you're only leaving behind like after it's divided up, let's say somebody gets 20 grand, it's probably not going to be necessary for that amount, but you're looking at leaving behind potentially a couple $100,000 per beneficiary or more. It can be very helpful to have that option at least. So talked a lot about taxes and I didn't talk a lot about administrative fees, but I can quickly run through some of the things that we see that increase the administrative cost and how you can potentially avoid these. The biggest thing that can determine the administrative cost of an estate is whether you use probate to pass your assets or whether you're using a trust settlement to pass those assets instead. So somebody who has a will plan, they don't have any sort of trust, they're just using a will, and they're sending their assets through probate. Wills only direct probate assets. So a lot of clients who have wills, they intend to use probate to pass those assets. And you can have a lot of very good reasons to use probate, like having minor kids that need guardians, having a lot of debt. I mean, there's very good reasons to use probate. But for some people, it might unnecessarily increase the estate administration fees. Probate tends to be more expensive than using something like a trust to pass those assets outside of probate because there's filing fees with the court. There's fees that the executor can take for their role, and those are generally around 2 to 3% that they're allowed to take and don't really get questioned. There's attorney's fees that tend to be more expensive for probate than trust settlement because it's more time and effort to get through that. So using probate can potentially increase administrative expenses. And if you don't need that process, it's unnecessarily increasing those expenses. So a way to lessen that is to look at using something like a trust to still put somebody in charge of bills, plan for the kids or unknown circumstances, but not have that court involvement and lessen the administrative cost. It's not going to eliminate it, but it can lessen it. A huge thing that we see, whether somebody's using a trust or a will, that can potentially create increased administrative expenses or burdens, at least, is when somebody doesn't have their estate properly coordinated, when their assets are not properly coordinated with their estate plan. So wills only direct probate assets. So if you have a bunch of payable on death, transfer on death designations on all your accounts, and those aren't going subject to the will at that point, well, that can make things much more confusing for the executor. It can make it harder to pay bills. It might mean that the attorney who's helping that person has to track down a bunch of other, things. It can increase that expense, but especially with trust administration, if you don't properly coordinate your assets with your trust, some of those assets may still be subject to probate. If they're outside of the trust and they're not designated to go to that trust when that person passes, there's no beneficiary on it, let's say, it will potentially be subject to probate. So now if you have a trust administration and a probate, now you're increasing that fee above and beyond if you just had a trust administration. So I would love to talk a lot more about how you can properly coordinate that, but I am running a little short on time. But just know that that's probably one of the biggest issues we see where it unnecessarily increases the cost of the estate or cost to the estate. So generally speaking, planning to avoid conflict can help. Anytime there's conflict, that can increase expenses quite a bit. Obviously, you can't force everybody to not fight. I mean, there's always a potential for it. But there's a lot of things you can do, just proper communication ahead of time, explaining your wishes, putting the right people in charge, things that you're not setting people up to fail or have conflict, working with an estate planning attorney to help make sure that that's actually the right way to do things or the best strategy to deal with these types of assets. That can help minimize that conflict because oftentimes we've seen where that conflict comes up and can give you advice as to how to avoid it. Again, nothing is bulletproof, nothing is 100% guaranteed to stop someone from fighting, but there's a lot of things you can do that might accidentally just increase the chance of conflict. And then the last thing, just because I am out of time here, one thing that I've seen that can really help make that estate administration much more efficient and therefore minimizing expenses is making sure that your executor works with the proper professionals when they're administering the estate. Now, not every estate is going to need an attorney to be hired if it's relatively minimal or straightforward, but at the very least, it's helpful to have a CPA that the person is going to work with, an accountant, somebody who can help them file the final tax returns, make sure that's done properly and effectively. Working with an attorney to help administer an estate can also get you through that process more quickly. And if the more things get delayed, the more potential expenses there are, the more potential years that something goes on, the more tax returns that need to be filed, right? So just working with the right professionals, CPAs, attorneys, financial planners that the parent worked with, I mean, that can all make this much more efficient and just get through that process more quickly. Now, it's still going to take time. An average estate administration for probate, for example, might take a year, year and a half. That's pretty standard. Even using a trust, it's not going to be over in a week or a month. It can sometimes take 6 months to a year. It just depends. But it is something that just working with the right professionals, whether it's an attorney, a CPA, or anybody like that in the financial industry, can really help make that much more efficient. So I'm not seeing any questions and I'm out of time. But if you do have any questions or anything I've talked about today makes you think, man, I'd really like to talk to somebody about this, keep in mind that we'll be sending out that feedback form where you can let us know to reach out to you to schedule that initial consultation. Again, those are complimentary. We schedule them for about 2 hours and can give you a pretty good recommendation usually at the end of it. But if you are just watching this later and want to reach out to us, you can always reach out to us directly. Sign up for future webinars at estateplanninglive.com or our public seminars that come up once a month as well. Thank you for joining me. I hope everyone stayed safe with the weather, and I will look forward to seeing you guys next.